Court this morning is the case entitled Flat Fee LLC et al. Versus Northwest Vermont Realtor Association, Inc. et al. Case number 24 AP 408. Representing the appellants, Flat Fee LLC, Robert Foley and Matthew Havers, is attorney Catherine Litka. Representing the appellees, Anne Marie Daniels, Hickok and Boardman Realty, Inc. and Catherine Wade, is attorney Daniel Burchard. Representing the appellee, Northwest Vermont Realtor Association, Inc., is attorney Thomas Nuovo. The appellees will be splitting time.
All right. And the appellees, you understand you're responsible for the time split. We won't be doing that for you.
Yes, Your Honor.
Very good. Counsel for the appellant, please introduce yourself and your client, and you may proceed with your argument. You have 5 minutes.
Good morning, Your Honors. My name is Catherine Litka, appearing on behalf of appellants Flat Fee LLC, Robert Foley, and Matthew Havers. May it please the court. This case involves appellants' challenges to unjust, illegal, anti-competitive rules in Vermont's real estate market, appellees' enforcement and benefit from these rules, and the resulting harm caused to appellants. Appellants should have had the opportunity before the Superior Court to present their case on the merits. The arguments before the court today are simple. Appellant's complaint contained allegations of anti-competitive activity and unjust enrichment separate from the challenges to the arbitration award. And second, the Superior Court also erred in its determination that appellant's challenge to the arbitration award was untimely. Turning to the first point. Appellant's complaint, especially with regards to claims involving anti-competition and unjust enrichment, met and exceeded Vermont's liberal pleading standards. And if there was a deficiency, appellants should have been given leave to amend their complaint pursuant to VRCP 15A. With regards to the antitrust and anti-competition allegations, appellants make important, impactful claims related to the antitrust activities in Vermont's real estate market, which are violations of the Vermont Consumer Protection Act 9 VSA 2451 et al. The complaint is rife with factual allegations of anti-competitive activity, which were not credited to appellants by the Superior Court. For example, on PC 45, quote, NVRA's commission fee rule is illegal and unfairly restricts competition. This commission fee rule that we're discussing has been declared illegal at a federal level in Burnett et al. Versus National Associations of Realtors before the Western District of Missouri. And that ended in an over $1 billion jury verdict. And turning to unjust enrichment, appellants' claims are separate and timely relating to unjust enrichment from their challenges to vacating the award. Appellants did all of the work for the buyer in the underlying case and ended up losing $18,000. Appellees did next to no work, sat back and watched appellants and collected. And there was no consideration of the equities during the arbitration process that could have been considered had an unjust enrichment claim before the Superior Court had been allowed to go forward. If this action and the taking by appellants is not addressed, appellants will continue to, by appellees is not addressed, appellants will continue to be harmed, resulting in inequity. For both of these claims, the Superior Court erred when it declared that declaratory judgment would not serve a useful purpose as it did on PC 10. Declaratory judgment would have served an extremely useful purpose as laid out in the complaint, not only for appellants, but for the Vermont real estate market as a whole, to clarify the legal issues that are related to these antitrust claims. The rules enforced by appellee NVRA and benefited by the remaining appellees create a stranglehold on the Vermont real estate market and those such as appellants who are trying to provide an alternative to consumers. So therefore, unjust enrichment and anti-competitive activity should have been allowed to proceed past the motion to dismiss stage. Second, Superior Court erred in finding that appellants' challenge to the arbitration award was untimely. This was not a case in which appellants sat on their rights and had their grievances with the arbitration until they were dissatisfied with an award. They repeatedly and consistently challenged the award. There are examples in printed case 56 through 57 and 64 through 67. Appellees were well aware at all times of the challenges made by the appellants against the process and the makeup of the arbitration court. Appellants' challenges here do not undermine arbitration, but serve to emphasize the neutrality of arbitration. Apologies, did I cut off, Your Honor?
No, you may continue.
Apologies. Appellees would not be harmed by allowing this challenge to go forward, and only appellants would remain harmed. Not allowing this challenge to go forward risks undermining the neutrality of arbitration, and appellees and allowing a warped form of arbitration to go forward in which biased arbitrators are allowed to make decisions. In conclusion, this case should have been allowed to be decided on its merits, and appellants request that this case be reversed and remanded to the Supreme Court. And if there are no other questions, I reserve the remainder of my time.
All right, very well. We will hear now from the appellees. You may introduce yourself and your client and proceed with your argument. You have 5 minutes that you're splitting.
Thank you, Your Honors. May it please the court. My name is Thomas Nuovo, and I have the honor of representing Northwest Vermont Realtors Association. Flat Fee's complaint was dismissed because Flat Fee failed to timely file to seek judicial review of the arbitration decision. On appeal, Flat Fee has made several arguments that they did not make below and thus should not be considered by the court. Flat Fee has not appealed the trial court's finding that Northwest Vermont Realtors Association was entitled to judicial immunity. Flat Fee argues in its complaint that his complaint was timely because it filed its complaint on April 4th, but that complaint was dismissed and they filed a completely new complaint on July 1st, and then thus the April complaint is irrelevant. The second complaint is controlling. There is no basis to relate it back to the April complaint, and Flat Fee has provided no legal support for its request. Flat Fee has also argued it should be entitled to amend the complaint, but no such complaint request was made below and thus should not be considered by this court here. Finally, the complaint fails to state an antitrust claim. There are only general references in the body of the complaint about which amount to conclusions of law, which are insufficient to support an antitrust claim. Also, none of the counts in the complaint assert an antitrust claim. Therefore, on behalf of the Northwest Vermont Realtors Association, we request that the court affirm the decision of the trial court. If there are no further questions, then I will rest on my briefs. Thank you, Your Honors.
Thank you, counsel. Mr. Burchard, please introduce yourself, your client, and proceed with your argument.
Thank you, Your Honor. Daniel Burchard. I represent Hickok and Boardman Ritty, Anne-Marie Daniels, and Catherine Wade. May it please the court, at risk of sounding just like Tom Nuovo, I'm going to just highlight some of the points that I think are salient here. First, I think it was appropriate for the trial court to dismiss this case. The original filing in April was properly dismissed and not appealed. It became a final and unappealable order. By the time the July complaint was filed, there had been sufficient time that had passed under both the federal and the Vermont Arbitration Acts to time bar this action. The appellant has argued that there should be relation back to the April filing, but there's really no reason basis for that under the rule for relation back or otherwise. There's no equitable tolling that applies in these circumstances, and so the judge was correct to dismiss the case. With respect to the argument that the unjust enrichment claim and the allegations of antitrust activity in the July complaint are sufficient to be standing alone, I think the court was also correct to conclude that those are collateral attacks on the arbitration award that are time barred by the time limitations of both federal and Vermont Act. Arbitration awards deserve to be upheld. The Vermont Supreme Court has repeatedly acknowledged that they should be upheld whenever possible. Here, it's more than possible. It's absolutely correct to uphold this award. The unjust enrichment claim seeks the same result as an attack on the arbitration award. It is clearly a collateral attack. The antitrust allegations were never crystallized into a viable claim. The assertion that they have made a Vermont Consumer Protection Act claim is one that was raised for the first time on appeal. It is not something the court should consider. And the reason for not considering arguments raised for the first time on appeal is adequately and amply demonstrated here, because they're standing arguments that need to be considered by the trial court before these antitrust assertions can be entertained as a valid claim. So in sum, the court should uphold the decision below, affirm it, and put an end to this litigation. Thank you very much. I'm finished. I rest on my brief.
All right. Thank you, counsel. Does the appellant have any time remaining?
Appellant has 44 seconds remaining.
All right, please proceed if you choose to.
Thank you, Your Honors. In conclusion, appellants make important claims relating to anti-competition, challenges to the neutrality of arbitration, and they should have been allowed to proceed past the motion to dismiss stage. Appellees have been well aware of appellants' challenges to their rules and the arbitration process as a whole, before, during, and now after the arbitration process went forward. They could make their arguments before the Superior Court, and I cede the remainder of my time and request that this case be reversed and remanded to the Superior Court. Thank you.
All right, thank you all very much. The bailiff may call the